Mr. Simon Guru, Mr. Cheche, and Mr. Muji.
This is the court. The ninth accused, Mr. Njenga, comfortable standing. Sorry. The ninth accused, Corinne, appeared before me for plea. He pleaded not guilty to several counts, numbering 7. For clarity, in the substantive charge sheet, count 1 to 7 of the 12 charges appearing in the charge sheet. Similarly, and for clarity of record, the co-accused who are not present in court took plea on the 9th of May 2023, and each was released on hold of 100,000 shillings with an alternative of cash bail of 50,000 shillings. They paid the cash bail and are expected in court for pretrial directions on the 20th of June 2023. The reason I bring this is because the learned senior counsel, Mother Karua, asked this court to either adopt similar terms of bond or, in the alternative, grant the 9th accused free bond. The basis of this is equality of the accused in trial process, and secondly, that the accused being a reputable leader with what she terms a substantive support base as a fixed place of abode. Similarly, she stated that the accused voluntarily appeared before this court on 24th May 2023, appeared voluntarily before the DCI Nairobi on the 25th May 2023, and as voluntarily and without summons availed himself in court today. She concluded by stating that the accused is not a flight risk. In a little digression to the application, the senior learned counsel asked the court to note the following. First, that the charges herein are politically motivated with the sole intention of curtailing the accused from mobilizing his political support base, hence infringing on the accused's political and civil right of self-expression, association, and assembly. She complained further that when the accused appeared before the DCI on 25th May 2023, he was, through tricks, whisked away from his lawyers, and it only took the intervention of the DPP for him to be reunited with his lawyers. This to her is a demonstration of mischief by the DCI. Mr. Njiru had this to say. Article 27 of the Constitution provides for equality before the law. He laid this basis on the alleged statement by the Deputy President, which in his view jeopardizes the trial of this case. He alleged that threats were issued to young men and specified, though, that they may face extrajudicial killings. He asked that this court should injunct all bodies and organs from making statements and inferences that may jeopardize the trial hearing or statements that are sub judice. he associated himself with the submissions by the senior counsel that the accused should be released on free bond. The lead prosecutor, Counsel Maina, steered away from direct response to the issues raised by the counsel for the accused. She went legal. She asked that the court should make independent view and not driven by mercy, as alluded to by Counsel Njiru. She submitted that the court in granting bail should be guided by the existing bond and bail policy and the relevant laws. She submitted in objection to the accused admission to free bond. She asked that the court should consider a bond of bail that is consummary to the offense. She had either no objections to the accused admission to bond. This is the determination. The law on accused admission to bond is clearly spelled out in Article 49(1)(h) of the Constitution. I deem it fit to restate, quote, an accused person has a right to be released on bond or bail